Previously, we have already uploaded and discussed regarding who is a Hindu and the various sources of Hindu law, the different schools of Hindu law, Hindu marriage, and Hindu divorce as per the Hindu Marriage Act 1955. And in this video, we will discuss regarding Hindu Adoption and Maintenance Act 1956. So, first we will discuss the very idea of Hindu adoption as we found under traditional Hindu law. So, according to Manu, adoption means taking a son as a substitute for the failure of a male issue, and according to Baudhayan, for fulfillment of religious duties and to continue the line of ancestor, a adoption of a male child was required, and as per the ancient Hindu text, there were five kinds of adopted son, but they are reduced to only two forms, and those two forms were Datta Ka and Kritrima. So the first one was prevailing throughout India, and the second one was prevailing in Mithila and the adjoining states. And as per the present act, and that is the Hindu Adoption and Maintenance Act of 1956, there was a secular character of adoption, and adoption of both son and daughter are being given under the provisions, and that is actual giving and taking of the child. And as regarding adoption, it is not recognized in other personal laws like Mohammedan law, English law, and the Parsi law. And there are certain revolutionary changes that we found under this act. And those revolutionary changes are the religious and spiritual consideration of adoption is completely changed under the present act, and the new adoption is secular in character, and those revolutionary changes that we found under the present act are: the first one, the act applies to all sects and groups among the Hindus, even to the converts and reconverts. And secondly, it applies to all the sub-schools of Mithaka and Dhyabhag alike. And the third characteristic and revolutionary change that we found: adoption of both boys and girls. And the fourth one, preference of Datta woman is made relevant. There is the need of actual and physical transfer and acceptance. And the fifth revolutionary change that we found under the Act that husband required the very consent of his wife for adopting a child, and the sixth one, wife cannot adopt during the lifetime of her husband without his consent. And the seventh one, wife can adopt even during her maidenhood. And the eighth one, she can adopt after the death of her husband if he died issueless. And the ninth one, the adopted child cannot divest any portion of any property in the adoptive family which has already vested in him. And now we'll go to the provisions as provided under Section 6 regarding the essentials of valid adoption. So, as per Section 6, the first one, the person adopting has the capacity and also the right to take in adoption. And the second essentials of valid adoption is the person giving in adoption has the capacity to do so. And the third one, the person adopted is capable of being taken in adoption. And the fourth one, the adoption is made in compliance with other conditions mentioned in chapter 2. And now we'll go to section 7 of the act regarding capacity of a male Hindu. So, as per the provisions of section 7, the very capacity of a male Hindu regarding adopting a child is of sound mind, and secondly, not a minor, and the thirdly, consent of his wife, and this is a mandatory provision unless the wife is finally and completely renounced the world or does not remain Hindu or has been declared unsound mind. And now we'll discuss a leading case relating to this very provision of section 7, and that is Praful Kumar versus Sasi Viva in 1990. The Delhi High Court expressed that wife has participated in the ceremony of adoption would be considered as presumption of her consent. So now discuss the second leading case, Krishna Chandra Sahu versus Pradeep Das, 1982, in the Odisha High Court expressed that without consent of wife, the adoption is null and void. And in case of judicial separation, the consent of wife would be necessary. In void marriage, the consent would not be necessary. A person has more than one wife, the consent of all wives would be necessary. And now we'll go to section 8, that is regarding capacity of a female Hindu regarding adoption. And the very provision of section 8 provides that she should be of sound mind, not minor, not married, or marriage has been dissolved, or husband is dead, or the husband renounced the world, or the husband becomes a convert, or the husband has been declared of unsound mind. So, adoption under void marriage would be declared null and void. So also, adoption under void marriage having a child of such marriage, then there would be no question of adoption, and adoption during maidenhood and after marriage by the husband with her consent would be held as valid, so the woman can make several adoptions. So these are the very provisions regarding the capacity of a female Hindu regarding adopting a child, either male or female, and that also has provided a revolutionary change in the very old Hindu law regarding adoption as a revolutionary change brought under the present act, and the act is Hindu Adoption and Maintenance Act 1956. So this revolutionary change, as it was brought under the act itself, made the very act secular in nature.